All right. Welcome to Selective Incorporation and Privacy, probably our two most controversial topics of AP government. So, without further ado, let's begin. All right. As far as the right to privacy, please understand this is a very controversial issue because of one thing. And let me just tell you what it is. When you look at the United States Constitution, and I promise you this is the entire text of it, uh, notice that if I were to hit Command Find and type in the word privacy, it would take me all the way down to the bottom. All right. Nowhere in the Constitution is the word privacy mentioned. Okay. So that's the first thing, is it's not mentioned in the Constitution. All right. Well, does that mean that it's not a right and that people don't have that right or not? That's the question that must be answered first, of whether or not there is a constitutionally protected right to one's privacy. Now, the court case that is going to ask that in 1965 is Griswold versus the state of Connecticut. Don't worry about that case. You don't need that case. However, it does ask, do U.S. citizens have the right to privacy? Long story short, yes. Okay? Long story short, yes. And here's why the government says it. Now, they use a variety of amendments to kind of imply privacy. So there's many different types of federal government power. So we have our enumerated power, which if you look in the federal constitution, you can see these. They are physically written down. You have concurrent powers that are shared between the state and federal government. And then you have those reserved powers that in the Constitution you also see these listed, or these are the powers that are reserved to the states. But in this situation, what they're saying is it's implied. So yeah, you're not going to find it. You're not going to find the word privacy in the Constitution, but it's implied. It's an implied right that you have. Now, as far as like their justification for it, I know I put 1, 3, 4, but I'm going to boldface 9 and underline it because that's the one they really, really concentrate on. And just basically like a very simplified interpretation of the Ninth Amendment says that all rights not listed in the Constitution belong to the people. Okay? And the Constitution has a lot of rights. Excuse me, there's a lot of rights that are not listed in the Constitution. And privacy is one of them. And so if we follow the Ninth Amendment to the letter, that would say that, yeah, privacy falls outside the Constitution. It is a right and it does belong to the people. Now, why is that controversial? Because it deals with topics like abortion, whether or not, if we do have this right to privacy, which was established, which was the precedent that was set in Griswold versus Connecticut, does privacy involve a woman's right to choose to terminate a pregnancy? What about the right to die? Now, I am going to include an assignment as far as the right to die goes. And I want you to take a look at this gentleman, Dr. Jack Kevorkian, and I'm going to link this video, Dr. Jack Kevorkian and the Right to Die, the Retro Report. There will also be a short worksheet that you need to fill out, but it does a really good job of explaining to you the right to die, but more importantly, the controversy that is attached to that. Okay? The controversy that's attached to that. Usually when I show this in class, students really, really like this video, but I would also ask you this. After watching this and completing the worksheet, ask your parents if they remember who Dr. Jack Kevorkian is, because it's kind of it's a very like shocking story, very controversial story, but take a look. All right, so for Roe v. Wade, which is the one out of all the cases that I have listed here today, it's the one that we need to know. What it's virtually asking is this. The precedent is set in Griswold v. Connecticut that the people have the right to privacy. Well, does that include abortion? Does that include abortion? All right, and what the Supreme Court rules is yes, it does include abortion. So this whole umbrella of privacy, abortion does fall under it. It is protected. Now, with Roe versus Wade, when a Supreme Court makes that decision that yes, privacy is a constitutional right, and yes, abortion falls under the right of privacy. So a woman is allowed to choose whether or not she wants to terminate a pregnancy. When they make a decision like that, remember, we're talking about that they're clarifying the Constitution, all right? They're clarifying the Constitution. They're saying, yeah, the Constitution says this, but it means this going forward. And when they clarify the Constitution, all groups underneath them need to follow suit, including all the states. So whether or not you were a state that was, for or against the policy of abortion, it doesn't matter. It doesn't matter. Now you are expected to uphold Roe v. Wade, which virtually says that states cannot infringe upon the first 3 months, okay? So the first trimester states, Roe v. Wade states you're out of the picture. You can't restrict the process. Now in the second trimester, months 3 through 6, and the third trimester, months 6 through 9, then states can get involved and they can place more restrictions. But that 1 through 3 month, states you're not involved. Now, moving forward, because I know there's been a lot of cases involving abortion recently and they've been on the news. Here's the new standard, okay? Here's the new standard. In Planned Parenthood versus Casey, which is a case you don't need to know, but I just want to show you how abortion is played out moving forward. Virtually what Pennsylvania did is they passed laws. Their state legislature passed a law that placed certain restrictions on the first 3 months. Okay? And Roe v. Wade says no, that's a no-no. And so what they did is they tried to pass a 24-hour waiting period. If you were a minor, you had to tell your parents. And if you were married, you had to have a signed statement by your spouse permitting you to do the abortion and other certain requirements as well. Now, in this ruling, it comes out and the Supreme Court says, okay, moving forward, abortion is still the law of the land, okay? It's still covered under the right to privacy. However, the new standard for any rule or regulation regarding abortion is called the undue burden test. Now, the undue burden test basically says that states are forbidden from passing any law or restriction that would place an undue burden on the process. And that's a fancy term for saying the law cannot be worded in such a manner where it completely outlaws the practice of abortion or it makes it near impossible for a woman to carry out that task. So, moving forward in the debate over, or the topic over abortion, these new court cases that are arriving to the Supreme Court regarding abortion are all about individual laws passed by the states. Okay, so let's just say the state of Louisiana passes a law regarding abortion, and it makes it all the way up to the Supreme Court. What the Supreme Court is going to determine is whether or not that law passed by Louisiana, or more importantly Texas recently, places an undue burden on the process. Does it make it nearly impossible or outright the process altogether? If it does, it's unconstitutional, and it's poof, it's gone. All right, but if it doesn't, it stays. And so for this one right here, moving forward, Planned Parenthood versus Casey, the court said, okay, we're fine with this. This doesn't present an undue burden. All right, this can still be in place and the procedure can be done. This one is also accepted. It can still be in place. It doesn't place an undue burden. It can still be done. This one's not. This one's not. Okay? This is unconstitutional. It would place an undue burden on the process. It would be nearly impossible for a woman to perform this procedure if this was in place. So boom, you're gone. Now, moving forward, states feel free to put these into practice if you want. You don't have to, but this is permissible. All right? So that undue burden test. Now, take a look at Dr. Jack Kevorkian. I really think you're going to like it. All right, now as far as selective incorporation, which is a very difficult concept to understand, and I'm hoping that I don't butcher it, let's try our best to really define it. But if there's any problems with the process, if you don't understand it, please contact me because I will figure out a better way to explain it to you. Now, in the beginning, when we're forming the Constitution, please understand that there's that debate, okay, that federal versus state power. All right, we even read a couple Federalist papers on it by people arguing on behalf of a stronger federal government and ratify this Constitution because a stronger federal government would provide these benefits. And then we read Brutus I, which argued the exact opposite, which was no, more power should be ceded to the states. The states should have ultimate domain within their territories and decide what they want to, and they should be very independent. What eventually happens is that debate carries over even into when we adopt the first 10 amendments to the Constitution, the Bill of Rights. All right. So all the way up to this point, we've been studying the Bill of Rights. All right, the Bill of Rights, the first 10 amendments to the Constitution. We've covered the First Amendment. We've covered the Second Amendment. We covered the Fourth, Fifth, Sixth, Eighth Amendment. So we've been doing our work. We've been finding out what individual liberties do you have as an American citizen. Now, in the beginning, okay, please understand that those individual protections that we've been learning about up to this point, you were only protected against the federal government. Hence, they're being roped. They're restrained. They're unable to do anything to infringe upon those liberties or violate those liberties. But it didn't say anything about the states. The states were not held to the same standards. So you kind of see the states off, like, boo, making fun of them, like, haha, that's funny. So technically, in the beginning, a citizen, their speech was protected against any infringement or violation from the federal government, but was not protected against any state governments. So nothing was on the books that prevented, like, the state of Illinois from passing a law that censored speech or took away one's right to assemble. What selective incorporation is it's bringing both parties into the same standard, okay? So at the end of the day, not only is your speech or your press or your right to assemble protected against federal infringement, it will also be protected against state infringement as well. Everybody is on the same policy. Everybody is operating underneath the same procedure as well. And the word incorporation, fancy term for just meaning just adding it into your daily life, or in states, adding it into the way that they operate. So, for example, if you're like saying, wow, man, I got to tell you, I've got to bulk up for sports next year. Well, you're going to incorporate a diet that has more calories. You're going to incorporate a weightlifting program. All right, you're going to add that into your life. So that's what we're kind of talking about with incorporation. Now, as far as the definition goes, I've already given it to you, so it's a long-winded one, so hold on. So what is it? What is selective incorporation? It's the Supreme Court using the 14th Amendment, specifically the Due Process Clause, due process, fair and equal treatment in the legal system, to apply a majority, but not all, of the Bill of Rights to the states on a case-by-case basis over an extended period of time. Wow. Okay, so that's a lot, all right? Now, why is the Supreme Court involved in this process? Now, remember, the Supreme Court is the ultimate interpreter of the Constitution. So, these individual court cases that we're going to see rather soon are going to ask, whether or not the individual liberties included in the Bill of Rights are protected against the states. All right? We know that we're protected against any federal violations of these rights. But are we protected against the states and their violations? Should the states be held to the same standard as the federal government? That's a constitutional question, and it needs clarification. That's where the Supreme Court comes in. Now, if you don't like the word infringement, what I did here is I just put down some synonyms, that might make a little bit more sense to you. But if not, I'm trying to make it as viable as possible. So why the Supreme Court? Because ultimately, this is a constitutional question. They're the interpreter, so that's where we go. Moving forward, why the 14th? You'll notice that with each of these cases that we see, I'll throw them out here, each one of these cases deals with the 14th Amendment. All right? Now why? Well, I've broken down the 14th Amendment into some bold-faced words that I want to concentrate on. It says, no state shall deprive any person of liberty without due process of law. So what we're saying here is no state shall take away one's liberty, i.e. liberties included in the Bill of Rights 1 through 10, without fair and equal treatment in the legal system. And when people look at this, they're saying, okay, I'm protected against the federal government, but not the states? That doesn't seem too fair to me. There's two different standards here. I want one universal rule. So, and also the 14th, because it's the first time that says state. Saying all the way up to the 13th Amendment, we've been talking about the federal government. Federal government, you can't do this. Federal government, you must respect this. Well, guess what? The 14th Amendment is putting the states on notice. Moving forward, states, you will respect liberties. You are prevented from, violating those liberties without due process of law. So that's why it's the 14th. It mentions that state. and it specifically discusses liberties. Now, what are we talking about on a case-by-case basis over time? All right, so here's what I mean. Remember, beforehand, the Bill of Rights only applied to the federal government. There were no court cases on the books that protected individuals against state violations. Now, here's what's happening. Notice that this process of selective incorporation is just not one case. So there's just not one case on the books that ask, are individual citizens protected against state violations or laws that infringe upon amendments 1 through 10? No. There's many different cases, all right? There's many different cases. Each case deals with a particular right. Remember, when we were talking about the First Amendment, we said, the First Amendment protects freedom of speech. There's a whole bunch of individual liberties included in these amendments. Yesterday, we talked about the Fourth Amendment, and we said that, you're protected against unreasonable search and seizures, but it deals with the exclusionary rule and with warrants and probable cause. And then we talked about, the Amendment 6 and this idea of, all these trial rights. So there's many different liberties included in these amendments, all right? So what these cases are doing are just asking about one, all right? Are states prevented from violating speech? Should they be held to the same standard as the federal government, okay? And in these cases, the answer is yes, all right? Now, once again, so what we're saying here is Gitlow versus New York is asking, should states be held to the same standard as the government? Are the people protected against any state violations in this cause? And the Supreme Court says yes. People are protected against state infringements. So moving forward, guess what? States, your policy will now be the same as the federal government. There's going to be no two different rules, all right? There's not going to be, I know that I'm protecting against the federal government, but I'm not sure. No, now it's one universal rule. Your speech is protected against the federal government and state infringements as well, moving forward after 1925. Then this case asks about press, okay? Is the freedom of press protected against state infringements? The answer is always yes, all right? So now, moving forward, your press liberties, freedom of press liberties, are now protected against the federal government and also prevents the states from passing any actions that violate that as well. One standard across the board. So on a case-by-case basis, notice that there's a bunch of different cases, and each one has one particular right, asking whether or not people are protected against the state infringements with it. Okay, now, what are we talking about as far as over time? Notice that these are not all done in the same year. It starts in 1925 and eventually moves all the way up to 2010. And it's a continuing process. So it's still ongoing. And what do we mean by selective? Notice that a majority of the rights included in the Bill of Rights have been incorporated onto the states, which that means that the states must live up to the same standard and same protections that the federal government provides as well. But not all. There's been no court case that's dealt with the Third Amendment. So technically, states could pass laws that trespass or violate. There's been no particular court case that's dealt with the Fifth Amendment grand jury. So states don't necessarily have to provide the same protections the federal government does. And there's none down here for the seventh in a jury trial. And then as far as excessive fines go right there, they're not on the books. So it's selective. It's a majority, but it's not all of the entire process. Moving in the future, there could be cases that do it, but right now they're not on the books. So it's selective. It's not total incorporation. All right, why is this completely controversial? It's because of this. Before the process of selective incorporation started, before the Supreme Court started listening to these cases and telling the states that the Constitution now means that they must live up to the same protections and standards as the federal government, and the people are protected against any violations from them, they used to have ultimate reign to determine exactly what kinds of speech and press we want to regulate. We get to determine exactly how we're going to handle criminal investigations and prosecutions and punishments. We get this idea to, regulate churches and, without interference from they had ultimate reign. With these incorporation cases, what's happening to them is now they're being brought on the same standard as the federal government. So now the states are being told that, yeah, I used to control this, but now guess what? The federal government is virtually going to be in charge of telling you what types of expression are allowed in books and magazines and what types are not. What types are not. They're also going to mandate that you enforce or prevent you from passing laws or enforcing rules that discriminate against certain marches or rallies or protests. And you got to allow them in public places. And we're going to tell you whether or not the Nazis are allowed to march through Jewish neighborhoods in Skokie, or if Florida is able to prevent the sale of a very controversial album by the Two Live Crew, as nasty as they want to be. So states are being told, you must do this, all right? We used to have liberty. No. Now you're going to do this. You operate on the same principles that we do. And so I always use this, and I'm sure that it's probably not going to make any sense, but I'm still going to say it anyways. I mean, this is what's going to happen probably to you in the near future. And what I mean by that is in 2 short years, you're going to find yourself in college, and you're going to be all by yourself, and you are going to have ultimate reign and freedom to do the things that you want in your time. Nobody's going to be telling you, you must do this. I mean, you have ultimate independence. And then you're going to come home for that first break. And you're going to stay out till try to stay out till 1 o'clock in the morning, and you're going to get a phone call from your parents where are you? You need to be home now. Well, wait a minute. No, hold up. I got ultimate. Nope. You need to be, you're underneath our roof. You're following our rules. And so I always use that kind of analogy as well. All right. So don't forget, Dr. Jack Kevorkian, the Right to Die worksheet. It's very, very good. I think you'll like it. If you have any questions, concerns, or comments, feel free to contact me. But without that, hey, listen, have a wonderful weekend. Take care.